Welcome to St. Peter's Law Academy. Myself, Dhirendra Kumar. Today I unravel before you a very popular concept, a very popular question in fact. And the question, which is oftentimes repeated as a proverb, is why the Constitution is regarded the supreme law of the nation. Because nowhere the Constitution itself has spoken of in these terms that the Constitution is the supreme law of the nation. Then on what basis do we say oftentimes that Constitution is the supreme law of the country? In order to be able to answer this question, we will have to first understand how the Constitution is there as a law, how the Constitution stands as a law. What gives the indication that the Constitution that we have adopted and given to ourselves by way of a Constituent Assembly is in the form of a law? Well, the first thing that is there in the Constitution is the preamble. If you cast a look at the text of the preamble, then you will see that we, the people of India, in this Constituent Assembly on November 26, 1949, have adopted, enacted and given to ourselves this Constitution. We, the people of India, on November 26, 1949, do hereby adopt, enact and give to ourselves Constitution. Now, to enact means to make law. It means that we, the people of India, through our Constituent Assembly, have enacted the Constitution. It means we have established the Constitution in the form of a law. The Constitution is a law. Now, further, if you cast a look at the oaths taken by the President and the Governor of states, the oath of the President is given in Article 60 of the Constitution. The format of the oath of the Governor is given in Article 159 of the Constitution. And these two constitutional functionaries, as they enter upon the office, they say that I, so and so, he is about to enter upon such and such office, do hereby swear in the name of God that I shall preserve, protect and defend the Constitution of India and the law. And further, Schedule 3 of the Constitution, which contains form of oath and affirmation for several constitutional functionaries, like the Prime Minister, takes the oath that I, so and so, who is about to enter upon the office of the Prime Minister, do hereby swear in the name of the God that I shall bear true faith and allegiance to the Constitution of India as by law established. Schedule 3, through its several provisions, is well enough indicating here that the Constitution has been established by law. It means the Constitution itself is a law. Now the question becomes, who gives us justification? What gives us justification to regard the Constitution as the supreme law? Do we have other laws also, among whom the Constitution stands on a superior position? Yes, we have several other laws in the form of ordinary laws or statutes. We have several other laws in the forms of statutes like Indian Penal Code 1860, CRPC 1973, RTI Act 2005, POCSO Act 2012. These are statutes, these are ordinary laws. And among them all, the Constitution abides at a superior or supreme position. That's why we call it the supreme law of the nation. But that is not a sufficient answer. We will have to explain something more. We will have to say something more in order to justify the Constitution being the supreme law of the country. Now, in order to be able to answer this question, you will have to first understand that Article 13 Clause 2 says, Article 13 of the Indian Constitution Clause 2 says that the state shall not make any law which contravenes the provisions contained in Part 3 of the Constitution, which means that any law, and here by law is meant several ordinary laws. Apart from several ordinary laws, notification, custom, usages, ordinances, etc., they also are included in the purview of the law. But ordinary law, if a state has initiated and have got enacted an ordinary law, then the condition is that ordinary law or that statute must not violate the provisions contained in Part 3 of the Constitution, which means any ordinary law violative of the fundamental rights is bound to be declared null and void in the process of judicial review, either by the Supreme Court or by the High Courts. So naturally, all the laws have to conform to the provisions of the Constitution, particularly the provisions contained in Part 3 of the Indian Constitution. Otherwise, they will not be allowed to exist. They will be declared null and void. So this gives supremacy to this Constitution of India. Constitution of India is supreme not because of the provisions related to the composition, structure and the functions of the government that we have at the union and state and local level. Constitution is supreme because of the fundamental rights of the people. Because the Constitution guarantees several fundamental rights related to equality and liberty to the people of India. And these rights are very supreme, very fundamental, because Article 13 has clearly indicated in so many terms that no law can exist which is violative of the fundamental rights. It means ordinary laws have to run subsidiary to the fundamental rights. They have to accord with the fundamental rights. Otherwise, they will not be allowed to exist. And this gives supremacy to the Constitution of India. And that's why we often regard it as the supreme law of the country. It is because of the fundamental right provisions. Thank you.